We'll start off with the Pledge of Allegiance, and just anybody who's going to offer testimony today, if you would stay standing after the pledge, I'll do a mass swearing in. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And anybody who's going to offer testimony today, if you'd raise your right hand. Right hand. Do you swear from the testimony you give is the truth, the whole truth, and nothing but the truth? Thank you. My name is Drew Smith. I'm the Code Enforcement Special Magistrate for the city. I've been practicing local government law for about a little over 20 years now. My role in these proceedings is to be an independent trier of fact. So are we going in agenda order, or are you changing up the order today?
Well, I wanted to ask, good morning, Jack. Good afternoon, Jack Morris for the city. There are attorneys here on two items, the unfinished business items, which are the Neptune Road case, unfinished business agenda item A, and then B is the Hickory Tree Road matter. Council's here for both of those. City has no objection with those being taken.
Then I'll take Neptune Road first, and then Hickory Tree after that, and then we'll go into agenda order.
That would be fine. Yes,
okay.
Sir. Okay.
So we will go in. Those two cases we'll hear first, then we'll go in the order of the cases. The clerk will call each case. When your case is called, the first step will be for the city to present its testimony and witnesses, or its evidence testimony. If there are any questions for the code enforcement officer, respondents will have the opportunity to ask those questions. If there are no questions, then you'll have an opportunity to present to me any evidence testimony you would like me to hear. Once I've heard all the testimony, I will enter a verbal ruling today that will be followed in the mail by a written order that each of you will receive probably sometime next week. And if there are no questions, then we can proceed to the first case, which will be Neptune Road.
Case number 2022-1666, Fernando Holmes, PA, owner, location of violation, 4601 Neptune Road, St. Cloud, Florida.
Your Honor, Jack Morrison for the city. This is a status hearing. You recall, I think we were here before you in February. Correct. So we simply noticed that council's here. I can apprise you briefly on the appellate status. With regard to this case, there was another case on appeal, but both of the cases from code enforcement that are up on appeal are fully briefed. We're simply waiting for either an order to be issued and or a notice of oral argument. Nothing, but it's been fully briefed. And the city's position is simply, we know and we have recognized and have been respectfully aware of the abatement or stay of any accruing fine, but the city's position is that we would like for a fine to begin for a couple of reasons. But number one, the city's position is that compliance can be achieved by this respondent, in the city's estimation, without any tremendous cost or effort. There's plenty and ample signage in addition to what constitutes the violation. And so there's not a financial impact for the respondent or an obstacle or a hardship, if you will, number one. Number two, in the event, and we feel confident in our position, of course, but in the event that the decision from a higher tribunal comes back in favor of the respondent, the appellant, the fine can be rescinded and move forward, and the city will obviously deal with whatever other consequence comes from that. So that's our position.
Thank you, Special Magistrate. Tim McCullough for Fernando Holmes, and I'd like to say Mr. Holmes is here with his family. Just a slight revision to the status that was presented by my good friend. The first appeal on the grass strips is fully briefed, and we're awaiting the circuit court appellate decision. A panel of 3 judges will get together, and the city has asked for oral argument, to which we've consented, so we're waiting to see if they're going to have oral argument in that case. A decision could come down at any time, or they could require oral argument, and then we would know that a decision would follow oral argument. But right now, we don't know exactly when that first panel will make its decision on that case. But the case that's really sub judice is this case involving the wrapped vehicles, specifically the message on the wrapped vehicles while they are parked in my client's parking lot. And there were 2 legal proceedings that were begun in that case. The first was the citation that was issued by the town of St. Cloud. Shortly after the issuance of that citation, Mr. Holmes filed for preliminary and permanent injunctive relief with Osceola County. We're still waiting for Osceola County to do something on that, even though we've pushed it along as much as we possibly can.
Have you had a hearing yet?
We have not had a hearing yet, and we filed, the county filed a motion to dismiss to our complaint. We filed an amended complaint, and in that amended complaint, we requested relief under 42 U.S.C. 1983 and declaratory relief as well as injunctive relief, to which the city responded by removing us to federal court. Now, we just found out about that this morning. So literally, that case has now been removed to federal court, and Osceola County no longer has jurisdiction over that case. We're in effect beginning brand new, and that court may well issue a preliminary injunction on the pleadings, as the federal courts are prone to do, because our amended complaint is accompanied by an affidavit saying it's true and correct, and would provide the federal court with relief, the ability to provide that immediate relief. But otherwise, we're all going to be in a position of getting ready to go before that court, following our trial plan, and otherwise complying with all the procedural requirements of the federal court. So in the appeal of this particular decision, which occurred after Mr. Holmes had filed for injunctive relief, that is not completely briefed yet. We've filed our initial brief, then the city filed its answer brief, and now we're within about 10 days of having to file our response brief. Now, the city would have the ability to file within about a 15 or 20-day period, and I forget exactly what it is, a rebuttal brief, or they can choose not to respond to that. So we're waiting to, that will be fully briefed in about a week. But the problem is, because of the removal to federal court, and before that, the failure of the Osceola County to give us any time to have our preliminary objection heard, or injunction heard, we have no idea when we can tell this court that any further proceedings that could be dispositive of this matter will occur. Therefore, I was going to request either another 90 days, in which case we may come back here and tell you we're still in a holding pattern, or an indefinite stay until either the appellate court rules or the federal court would rule. Thank you.
Anything, Jet?
Yeah, the information that was presented here now is contrary to my understanding, having talked to our firm's lead counsel on the appeal of this particular matter. Our answer brief, from the information I have, was filed May 6th. So I guess I stand with the understanding that a reply brief could be forthcoming. But the matter with regard to the citation and so forth, it's my understanding the injunction, that's a separate initiated action outside of these code enforcement proceedings. So aside from a reply brief, here we sit.
Okay. Well, so here's what I'm hearing, and who filed what when is less important to me to hear that the cases are moving along. I don't hear anybody saying that the other side is delaying or dragging their feet, correct? Okay. Given that, and I understand and I'm sympathetic to the city's position, but just as we heard the last one, I do disagree to a certain respect with the minimal cost. The financial cost of moving the vehicles is minimal. I understand that. But we're talking about a First Amendment right. And I think the city will prevail. That's why I ruled in favor of the city. But if we're wrong, or in this case, respondent, prevails, asking them to give up that right for a period of time is still a cost to them. And I still see the case that way. So you've accomplished what I wanted to hear today, which is that the appeals, and I know this is on the one case, but the appeals, the deck action, everything is moving forward. Nobody's dragging their feet. There will be an eventual resolution. For that reason, I'm still not going to issue a blanket stay. I want to keep my eye on these and make sure that everybody is doing what they can to keep these cases moving forward so that we have resolution as soon as we can to these questions. So I will stay, I guess it's a stay of the order for another 90 days. So that I had set, last time I'd set a compliance date of today. I'm not going to keep bumping the compliance date. I'm just going to stay it and provide in that order that in 90 days or the 3-month period. What day will that hearing be? So it'd be 3 months from today's or 3 months.
August 16th.
So at the August hearing, we'll hear another status hearing. I will reserve the jurisdiction to enter an order. So just as I said last time, if there's no progress and if respondents are holding it up, if you're dragging your feet, then I may say, okay, I'm going to give you a compliance date now, based on what's going on. But as of now, I'm going to stay and not have a rolling compliance date for them. I think it just complicates it.
May I ask a clarification question? So the stay will be imposed up through and including the next, or the August code enforcement meeting, which is August
16th.
16th?
Correct.
And does that status hearing have to be renoticed, or can the?
Yes, just to make sure that I'm sure they will be here. They're hearing what I'm saying now. But if they're not here, I would have reservations entering any kind of order without them present, unless you'd check the 162 box of yes, notice was sent. So that's just a due process issue. Let's go ahead and make sure we formally notice. Any questions?
Thank you, Special Master.
Good? Jack, good? Understood? Okay.
Case number 2022-83, Hickory Tree Industrial LLC owner, location of violation, vacant commercial property, Hickory Tree Road, St. Cloud, Florida.
Afternoon, I'm Jack Morgeson for the city. This matter was heard, there's a notice of hearing in motion for amended findings of fact and order increasing fine, which is in your packet. I'm sure you probably reviewed it. But there is counsel here for the respondent. Mr. Spain is here with his client this afternoon. The motion captures what the city is seeking. This case was heard back late summer. The order, fact, and so forth, the findings were back in August. The compliance was to take effect by November. Fine began to accrue after November 17th of last year at $100 per day. To date, our understanding is nothing's taken place. I know there's been some discussion between City Attorney Manzares and Counsel Spain. I haven't been privy to those discussions, but in terms of the case itself, nothing has taken place with regard to achieving compliance. The city is looking to get compliance. My understanding is that there may be not quite the incentive based upon the value of the fine, in that the property is a revenue-generating property. And so from a financial standpoint, the math, if one does the math, the fine may be a less of a pain than the situation with the current operation. So the city's hoping to incentivize the respondent to achieve compliance by increasing the fine. That's why we're here. Thank you.
Respondent?
Good afternoon, Mr. Smith. For the record, Brent Spain, Theriac in Spain, 1809 Edgewater Drive, Orlando, Florida. If I may approach.
Yes, sir. Can I keep this? Before I look at it, does counsel have?
You have a copy of that stuff? No? This is all of it?
Yeah, that's what he handed me. While he's looking at it, if you want to go through and tell me what it is you want me to look at.
Sure, no problem. So what I've introduced into the record is a packet of, it's tabbed 1 through 16. They're all public records, so I'm not creating anything that doesn't already exist. In fact, just to sort of tie this into the concept that nothing's taken place, I would just respectfully submit that's not accurate. These records came from a public records request our firm filed on March 28th. We got retained in March of 2023 to find out what is going on with our clients' development applications. Ironically, I don't think it's any coincidence that after our firm submitted a public records request, that then suddenly there's this motion trying to increase the fine. But when you walk through these exhibits, and I would like you to have them in front of you, but I'm just going to identify sort of what they are. As one, just sort of going back to the beginning of this, is behind tab 1, it's undisputed our client filed a small-scale plan amendment application, a rezone application in August of 2021 with the city. So there's a copy of that, seeking to rezone the property from highway business to industrial 2 and to change the flume to industrial. Behind tab 2 is then an email from the assigned planner, and this is dated November 30th, 2021, setting forth to my client the hearing schedule on that rezoning and the flume amendment. So it was going to go to the P&Z in December of 21, then it was going to go to City Council on January 13th of 2022, and then the City Council on second and final reading on January 27th, 2022. Then when you go behind tab 3, that's the actual staff report for the January 13th, 2022 City Council meeting for both the rezone and the flume amendment. Staff recommended approval, found it entirely consistent with the comp plan and the land development code. Behind tab 4 are the minutes to the January 13th, 2022 meeting where the City Council on first reading approved the rezoning and the flume 5-0, with the only stipulation being motion to approve with stipulations to be added to address noise concern prior to final reading. So our client was under the understanding initially that, well, the final reading is going to be January 27th, 2022. And this all chronologically becomes important because the matter didn't even get to you until August of 2022. So you then have an email behind tab 5 from one of the city planners on January 13th, 2022, and she's discussing what took place at the City Council meeting, and you'll see some text highlighted. But it talks about we would likely need to continue the item at the 127 meeting to the date certain of February 10th meeting to allow time to meet next week. So this is to discuss the stipulations on noise. And then in the next paragraph, I believe it's highlighted, it says the property owner was perfectly okay with this as code enforcement does not have an open case on the property currently as they are awaiting the outcome of these hearings. So in January 2022, city staff is saying, hey, there's no code enforcement. There isn't going to be any code enforcement until these hearings work their way through because the land use and zoning change would moot out these arguments, the alleged violations. So tab 6 is just the City Council press release confirming the vote that took place to approve it. Tab 7, you have an email again from one of the city planners, this is January 24th, talking about the approach is to define the buffers and walls and any sound requirements our code requires, and then work toward additional commitments as part of the request. Then you'll see a shift, tab 8, there's an email, January 31st from Veronica Miller, directed to the staff indicating that, hey, you need to do a summary of this and see where this matter stands before it gets set for a second reading and comes back. Next tab, tab 9, suddenly you have an email from the new city planner that was assigned the case telling our client, you can't seek I-2 zoning anymore, you have to go to I-3. So you need to submit a whole new application under the belief that the proposed use isn't allowed in I-2. And I gave you an excerpt of the Division 17 of Land Development Code, the industrial districts. And I'm sure you may be familiar with it, but the I-3 district doesn't set forth any uses in the use table. In fact, I-3, all the uses that are allowed in I-3 are those that are allowed in I-1 and I-2. The difference being that I-3 is an industrial PUD, so it's supposed to be a larger industrial park. And interestingly enough, on page 6 of that 21-page handout, sub C says area regulations for an industrial plan unit development are as follows. Sub 1, minimum area. Industrial plan unit development shall contain at least 5 acres of land. The subject site is about 2.6 acres. So my client's being told in February of 2022, your pending application has to be put on complete hold and tossed aside. You have to come in under I-3 because your use isn't allowed in I-2. And you have to do this industrial PUD even though you're 2.6 acres, and the code says you can only be I-3 if you're 5 acres. Nonetheless, behind tab 10, my client in July of 2022 submitted an application to go from highway business to I-3. Then you'll see behind tab 11, there are DRC comments from August 3rd, 2022 on that submittal. And you'll notice that under all the departments, there are no comments listed. Suddenly then, behind tab 12, and this is a critical date, there's an email from Ms. Sagara dated August 17th, and that date may sound familiar to you because that's the date of the magistrate hearing last summer, providing an update for the code enforcement officer to bring before you. And that email talks about how, while they resubmitted in July, they can't go I-2, they got to go I-3, et cetera, et cetera. And for the reasons I just stated, that suggestion's erroneous under the city's own code. Tab 13, you have the minutes from the August 17th meeting. I will note it's undisputed. My client, the respondent, wasn't present at that meeting, so none of this background, to my knowledge, was presented. I didn't represent Mr. Wright then. Mr. Wright was in the hospital that day and unable to attend the meeting. So the order was entered. Then you'll see behind tab 14 is an email from late September 22nd, 2022, where the planner gives an update on the status of the code enforcement hearing and our client's resubmittal. Again, this resubmittal to I-3. Behind tab 15, you'll see an email exchange between the city planner, and this is September 23rd, and our client's agent, where our agent indicates they've submitted the engineered plans and additional exhibits, and the planner advises them those exhibits won't be routed for review until they are properly submitted to the development coordinator. So I presume through a e-portal or something. And then behind tab 16, this is the last suddenly we heard from the city on this issue is, again, our firm got hired in March of 2023. We started evaluating this issue. We submitted a public records request on March 28th, 2023. And then on Thursday, April 13th, 2023, a newly assigned planner on this case emailed Joe Thacker, our client's co-counsel, advising that they're the new project planner for this request. I want to confirm if the applicant is submitting an updated application or if the applicant is pursuing the initial request as shown in the attached applications. And that's the I-2 application. Staff will confirm the public hearing dates once this information is verified. Well, you'll see I responded on April 21st saying our client intends to move forward under the original application, the I-2, because we submit I-3 is not needed because I-3 is for a large-scale industrial PUD. And subsequent to my email, I did speak with Mr. Manzares, and he reached out to see, because he had sent an email saying, well, the entire process needs to start anew. You have to have a new first reading, a new second reading, because there are two new commissioners. And I have my reasons for having concerns about that because it potentially restarts the record, and there's already a record in here with a staff report saying our application meets all the requirements. So Mr. Manzares indicated, he stated, I don't believe I have any legal authority to require you to start over, but I think it would benefit your client because there are two new council members. I said I would speak with Mr. Wright about that and circle back with him as long as we can get on consecutive meetings. But here we are with a notice being filed seeking to more than double the fine under this assertion that nothing's taking place. The property owner's not doing anything, where these 16 tabs show that the applicant did do something. They were filing for the requested rezone in Flume before the matter was even brought to you. They were told, hey, this is going to have to be continued in January of 2022. But don't worry, there's no code enforcement proceedings taking place, so the owner's fine with it. Then code enforcement does initiate the process, all the while an application is sitting out there awaiting a second reading to be scheduled. I don't schedule that second reading, you know that, and neither does Mr. Wright. We can send emails and inquire about it. But we've done that now, so there's no doubt that we're trying to get on an agenda. The only question is, are we going to do a first reading again and then a second reading, or are we just going to go straight to a second reading? So under that background, I don't think any of these facts are disputed. These are straight from the city's files. I think fundamentally it would be unfair to penalize the property owner by doubling the fine when the city really is the one that, whether through oversight or changing it to I-3, the matter never got scheduled for public hearing. And now that Mr. Wright has new counsel, I can assure you we're on top of it and trying to get the matter scheduled so it can be mooted out.
So the case involves business tax receipt and certificate of use. Brandon, if you'll step aside 1 second, let me get Jack back up because I have a question for the city. And I may ask you for your side of the story on this one, Brent. So the case before me involves a business tax receipt, and certificate of use occupants, or certificate of use license. Has there been an effort to pay for a business tax, or pay the business tax?
Appreciate the question. If I could, Community Compliance Officer Howes is here, and she has the detailed
Perfect.
knowledge.
That'd be
She's
great.
here if I can
Absolutely.
present her. Thank you.
Were you sworn?
To provide, yes, she was, and to provide you direct answers to your questions as well as provide some rebuttal information with regard to the presentation by council.
And before we get too far into the weeds, I see there's a process. As both of the lawyers know, I can't tell the city council what to do. But I can take under advisement, what's going on, especially when, part of the city's position is that respondent's doing nothing. But first off, I want to get down to what the case is about. I want to get refocused on this case. And business tax receipt and certificate of use. Has a business tax been paid or
No, sir.
attempted to be paid?
No, sir.
Okay, and certificate of use, I'm guessing if they came in and asked for a certificate of use license, they would be told no, because right now they're in a zoning process.
Correct, and that's
So
where the whole situation started.
They cannot, short of stopping business,
Correct.
stopping operations on the site, they cannot comply with certificate of use until they get through with the zoning process.
That's correct.
Okay. Let me stay, I'll invite you back up, but let me get the respondent up there, so don't go far. Let me get respondent up there, because now I'm going to ask the questions along a similar vein to them. Why hasn't a business tax been paid?
Well, I think you nailed it on the head. It's a chicken or
They'll
an egg.
accept the money. Why hasn't business tax been paid?
Well, the business tax, I think they'll say the same thing in my experience, is that you don't have the proper zoning to operate that use on the property.
Has it been attempted?
I don't know if it's been
Ask
attempted
the
or
client,
not.
he's nodding his head, he may have an answer for me. He was
He's
sworn.
indicating yes, he has.
He was sworn. He can provide the testimony himself.
Right.
And if you would state your name for the record, please.
Randy Wright.
And so you say, yes, you have attempted to pay a business tax?
We didn't attempt to do it ourselves. Our tenant tried to.
Okay.
And I can talk a little bit, or?
Absolutely. Go ahead. As long as it's kind of on the point of my question.
Absolutely.
Okay.
It's on all of it. When they first approached me, wanted to put a mobile crusher plan in, I said, I don't know, I guess we need to check and see. And we pulled it up on the web, and Osceola County had that parcel listed as vacant industrial. And I said, yeah, I told him, man, you're good to go. That's what we got to be, but you need to get with the city. They went down to the city to try to get everything going, and they said, well, that's zoned highway business. You're going to have to get it rezoned. And they asked them, well, are we able to bring our mobile crusher in? Because at that time, 300 yards away was another crusher plant going at the same time. And they told them, yeah, you're able to go and get running. The city told us this, that we're able to go ahead and start crushing while we're in this process. And they tried to get everything and do it right, and they said, no, we have to wait until you have it rezoned before you can get your business license and everything. So they definitely did try to do it. And this thing has been a moving target ever since we went through our first reading and it passed 5-0. I mean, I'm a working man. I'm not a baby beneficiary of anything. And, you know, that $100 a day is a very serious thing to me. Almost as serious as what I have to pay this man, the other planner that I had to hire to unravel it, and the other attorney that I hired before that. I mean, it's been a heck of a process, and it's been on my mind. I think that was part of the reason why I was in the hospital last time when I didn't make his meeting. It's crazy the effort we've put into this thing, and this poor man here, his father spent $1 million on this crusher after they told him, hey, you're okay to go. He wouldn't have done that if the city wouldn't have told us, hey, you're good to go. If they said, hey, you need to wait, they would have waited. But this man has spent this money, and he's a hard-working man. He's a man that's there every day. And it's unjust what's going on right now. We're trying to do what we need to do. We're spending the money to try to get it done, but they're making this thing a moving target. And I won't go into why that is, but it's an issue.
Yeah, none of my business is why that is, because
Exactly.
I can't fix that for anybody, whatever's going on. Okay, if you'd step aside and let me have the code enforcement officer back up. Yes, ma'am. You've answered my questions. What would you like me to hear?
Okay, so originally back in July of 2021, when we first started this case, the complaint was that there was a concrete crushing business going on at this location. And the complainants, and I have the gentleman's name here, is the original complainant who keeps continually calling me. He has an in-ground swimming pool with no screen enclosure, and he has given me photographs of the concrete dust that is accumulating in his pool and on his deck. And it's from the crushing of the concrete. We do have 2 other concrete businesses there, but they don't crush the concrete. It's a concrete mixing, Mashmeyer Concrete, and there's another one. And they have walls built up, they have the berms built up, they're all licensed and they're good to go. So the bottom line was, when we got out here, excuse me, when the gentleman had started the business, and I don't know if you remember the photos, he had put in an office trailer, he had put in a homemade septic tank hooked up to it, he had pipes, he had running water that they had made water come from Mashmeyer's that they had run over illegally. They were fixing vehicles on site, and they had abandoned vehicles. There were so many violations, and I mean, they were right when I said, you know, if you fix these violations, we'll hold off, you know. So we held off as long as we could until we kept getting complaints, and then we started the process. As far as the zoning goes, I don't know anything about the zoning and their process, how they work. I did get a detailed list from them of what they've done. And apparently what they told me is after that first reading, it was misrepresented that they were not an actual concrete mixing plant, that they misrepresented it, that they were a crushing plant. And apparently that has a different zoning than concrete mixing and concrete crushing. So we have, you know, typically you go through the site plan approval, you get all your approvals, they'll tell you what you need in order to, like Mashmeyer has the watering system going in and out of their property to keep the dust down when we don't have rain, obviously. There's a wall, there's a berm, there's requirements that are set and forth in order to have a business. But we just set the business up without even getting our business licensing, and that's where it came from. So, but as far as the zoning goes, I mean, I don't know. I cited him for no business tax, no certificate of use, and no permits. He has since removed the office trailer, the septic tank, and the water lines. I believe they're still working on their equipment there because they have nowhere else to go unless they go on Randy's property. I don't know, because he does own several properties in the area. And his property is in the county jurisdiction. So,
So what work is going on this site?
well, I've got photographs that I can give to the attorney,
Or
and
you can just tell me. I just want to understand.
I will say mounds and mounds of concrete that they
So
are
the crushing activity is
Oh,
still
yeah,
going.
and
That's what I wanted to hear.
I mean, I
There is
can't even
business
tell you
activity
the
still
height.
going on.
The height is humongous.
I mean, the case is about conducting the business without business tax receipt or certificate of
That
use.
is my
So
case, yes.
the height of the mounds, all that is more or less irrelevant to me today because the central question is business activity going on?
Correct. And I am still receiving complaints. And obviously, you know as well as I do, we've had no rain. So when that wind picks up, it is blowing. I mean, Randy's been great to work with. I mean, he's not been argumentative to me whatsoever. His tenant has not been. I mean, they've tried to cooperate with me as much as possible. But as far as, like I said, the planning goes and who makes those upper management decisions is not mine.
Nor is it mine.
Okay.
But I, for the purpose of this hearing, I do factor in what you said and the history. I appreciate that. But again, I can't do anything with what's going on there. That is ultimately has to go through its own process. Anything else from code enforcement
No, sir.
right now? Brent, you have anything you want to say?
Well, I think we're almost in a strange universe where I think most people here are actually in agreement in the history of the site. I mean, I still draw you back to the email from last January from the planning department indicating about having to continue the hearings and saying the property owner's okay with that because there's no code enforcement proceedings. They're going to wait until this hearing process runs its course. And then here we are trapped and pulled into a code enforcement process. I'm not here, not yet, asking for that $100 accrued fine to be reduced or waived, but to sit here today and say, oh, well, you need to stick it to them and more than double that fine because they're not taking it serious and doing anything about it. My packet demonstrates the exact opposite. We're sitting here saying, hey, schedule us for a hearing. And after I specifically asked in April to do so, the city told me, well, we're going to start the whole process anew. So we're trying to get that figured out. But there's no doubt we're going to go to a hearing on it. And as soon as we have zoning and land use, you can get the BTR and the occupational use permit or whatnot. But to double the fine, I think, is not justified under the facts.
Okay. Anything else from the city before I rule? Here's what I'm gonna do, since I have the date written down in front of me, and it fits with kind of where my head's at on this case too, but I'm gonna set this for status hearing on August 16th. I'm gonna withhold on the motion that's made. I'm gonna give the respondent time to keep working through that city council process. Some of that, for a lot of reasons, you hired a good lawyer, but you hired a lawyer that I know. And so I trust that the process will move forward because of the lawyer that you hired. So part of my ruling is, you know, I don't rule on personalities, but it is, I trust this to move. If I find out differently in 3 months, then I may rule on that motion to increase the fine. So it is imperative for the respondent to do everything in its power to move that forward, and you've hired an attorney who's going to do that for you. So I'm gonna reserve ruling on this motion, and we'll have status hearing in August. Okay?
Case number 2022-1843, Great House Pros, Inc., owner, repeat violation, location of violation, 1022 Carolina Avenue, St. Cloud, Florida.
Sorry.
Okay, I'm making my own notes too. We have it.
Good afternoon. Alex Miller, Community Compliance Officer for the City of St. Cloud. This time, I would like to enter into evidence the following items. Copy of the notice of violation sent by certified mail, posted at the property in City Hall. Copy of the statement of violation and notice of hearing sent by certified mail, posted at the property in City Hall. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds this respondent in violation in the amount of $256.70, and the respondent is not here. On January 2021, the magistrate found the same respondent in violation of doing work without a permit at the same address. On October 6, 2022, during routine patrol, I observed that the house at this location was demolished. I verified there was an active permit, but only for interior residential repairs and alterations. I called the owner and explained that the violation can be considered as a repeat and requested that he contacts the building department to correct the violation. A picture of the house prior to the before the demolition. On October, sorry, I have two pictures. This is what the house was demolished. On October 18, a reinspection was performed and verified that the owner did not correct the violation and additional work was performed. The building official asked to red tag the property to prevent further work from being performed, and 2 photos were taken. On January 18, a reinspection was performed and verified the violation was not corrected. A notice of violation was sent by certified mail to the owner, agent, posted the property in City Hall, an affidavit of posting was created, and 2 photos were taken. On April 5th, the building department sent an email requesting several items to be corrected on the application and a second request to apply for the demolition permit. After several emails back and forth between the respondent, the building department, and myself, and allowing almost 6 months for the permits to be obtained, on April 17, I verified that the application for the demolition permit was not submitted and the permit for the new dwelling was not issued and the property was still in violation. A statement of violation and notice of hearing was sent by certified mail to the owner, posted the property in City Hall, an affidavit of posting was created, and 1 photo of the posting was taken. On April 22nd, I advised the owner that he was still missing the application for the demolition permit after receiving emails on January 27 and then again on April 5th requesting that an application be submitted. On April 28th, I verified that the demo permit application was applied for and issued on the 28th, and the permit for the new dwelling was also obtained, and the property owner is now in compliance. It is the city's recommendation that the respondent be found in a repeat violation of allowing work to exceed the scope of work intended on the permit, obtain that it was revoked, and not obtaining a demolition permit and a new permit prior to start the construction on the new dwelling at this location. Pay a fine in the amount of $100 a day, commencing on October 6, 2022, the day the violation was found. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $256.70 to be paid within 7 days of the written order by the special magistrate.
What was the date the compliance was achieved?
April 28th.
Mm-hmm.
I'm figuring
You got
it
it?
out for you.
Good.
It is 205 days.
So you're asking for a $20,000 fine.
Yes, sir.
And walk me back through, so the demolition was completed without permit? Yes?
Yes, sir.
And you say there was a permit that was revoked?
So the permit was first obtained to rebuild this house right here. So he was cited first for not having a permit back in 2021, and you found him in violation.
That's the original, that's
Yes,
what
sir.
makes this repeat.
Yes, sir.
Okay, so
then-
go back to that picture.
Yes, sir.
So there was a permit issued to rebuild this house?
To do interior repairs and
To do a
alterations only.
renovation, not a
Yes, sir.
tear down and rebuild?
Yes, sir.
And then he did a tear down and rebuild?
Yes, sir.
And there were no permits issued to support the tear down and rebuild?
No, sir.
No, I understand. Okay. Anything else from city?
No, sir.
Is respondent present?
No, sir.
Okay. Significant project, and those questions help me understand the fine.
Yes, sir.
And based on the evidence testimony presented, I'll find in favor of the city, find that this is a repeat violation, find that it was a significant violation in tearing down a structure and rebuilding a structure without permits when permits were to renovate the existing structure. So I will also enter that award of $100 a day for each day the property remained in non-compliance or remained in violation of code. That was 205 days. At $100 a day, that brings the total fine amount to $20,500. We'll also enter an order or enter an award of the costs incurred by the city in prosecuting this case in the amount of $256.70. That amount will be due within 7 days from the date of my written order. I suspect I'll be hearing from the respondent eventually, but I am going to go ahead and give some extra time to get that process. I'm going to give 90 days to pay that fine.
The cost as well.
The cost is 7 days, typical 7 days from the date of my order, but I suspect there will be a request to reduce that fine amount before all is said and done, so I'll give them some time to either pay it, to come up with the money, or to make that request. Anything else in this case?
No, sir.
Thank you.
Thank you.
Case number 2023-113, Marc Antonio Echevarria and Lynette Marie Torres, owners, location of violation 3610 Scarlet Oaks Drive, St. Cloud, Florida.
Alex Miller with the City of St. Cloud again. At this time, I would like to enter into evidence the following items: copy of the courtesy notice sent by regular mail, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail posted at the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $253.70, and the respondent is not here. January 20, 2023, during routine patrol, I observed a gazebo was installed in the rear side of the property and verified that there was no permit issue in our city records. A courtesy notice was sent by regular mail to the owners on record to correct the violation. On February 6, a reinspection was performed and verified that there was no application submitted and the property was still in violation. A notice of violation was sent by regular mail to the owners to correct the violation. On February 22nd, I called the owner and asked if they have received my letters. The owner stated that they did, and they will be submitting the application soon, and additional time was provided for them to come into compliance. On March 2nd, a reinspection was performed and verified that the property was still in violation. On March 3rd, a notice of violation was sent by certified mail to the owners to correct the violation. On March 21st, a reinspection was performed and verified that the violation was not corrected. A notice of violation was sent by regular mail to the owners to correct the violation. On March 22nd, I posted the property in City Hall. An affidavit of posting was created and 4 photos were taken. On April 5th, a reinspection was performed and verified that no application was submitted. I called the owner again, and they stated they were waiting for the architect drawings in order to submit the application. I allow more time to come into compliance. Then I sent an email to the building department requesting an application to be sent to the owner. On April 24th, I received an email stating that the owner has been traveling and she will be hiring an architect to help with the permit application process. On May 1st, I verified that the property was still in violation. A statement of violation and notice of hearing was sent by certified mail to the owner. On May 2nd, I posted the property in City Hall. An affidavit of posting was created and one photo was taken. On May 12th, and again today, I verified that the permit has not been obtained and the structure has not been removed, and the property is still in violation. One photo was taken. It is the city's recommendation that the respondent be found in violation of allowing a gazebo to be installed at this property prior to obtaining a permit by the time specified. The city will recommend that the respondent be given until June 1st, 2023, to obtain the permit or remove the structure, or a fine in the amount of $100 a day be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $253.70 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation.
Is respondent present?
No, sir.
When's your most, you heard from respondent in March. Have you heard from respondent since March?
The last call I received was on April 24th.
Were they still waiting for architect drawings?
She just hired an architect.
No, that was April when they said they were waiting for an architect drawings.
Yeah, yes, sir.
Okay. Based on the evidence testimony provided, I'll find in favor of the city, find that the respondent is in violation for construction without a permit. We will allow the respondent until June 1, 2023 to obtain the permit or to remove the work that was done without permits. We'll also order the respondent to pay the administrative costs incurred by the city in the amount of $253.70. That amount will be due within 7 days from the date of my order.
Thank you.
Case number 2023-166, Nathaniel Mahilla and Rancelia T. Benitez Altagracia, owner, location of violation 2971 Micaiah Court, St. Cloud, Florida.
You got all of them today, huh?
Alex Miller again for the City of St. Cloud. At this time, I would like to enter into evidence the following items. Copy of the notice of violation sent by regular mail. Copy of the notice of violation sent by certified mail. Copy of the notice of violation sent by regular mail, hand-delivered and posted at City Hall. Copy of the statement of violation and notice of hearing sent by certified mail, posted at the property in City Hall. Copy of the PowerPoint presentation, affidavit of posting, evidence of mailings, copy of the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $265.70. And the respondent is here and has been provided with copy of the case.
Thank you.
Okay, I'd just like to let you know the property history. The property has recurrent violations of abandoned vehicles at this location. And on February 1st, 2023, during routine patrol, I observed vehicles parked on the driveway at this location, and they did not have current registration tags properly attached to the vehicles. Notice of violation was sent by regular mail to the owners to correct the violation within 10 working days, and 5 photos were taken. On February 20th, a reinspection was performed and verified that the violation was not corrected. A notice of violation was sent by certified mail to the owners to correct the violation within 10 working days, and 3 photos were taken. On March 13, a reinspection was performed and verified that the violation was not corrected. Notice of violation was sent by regular mail to the owners. On March 14, while trying to post the property, the owner came outside and was giving me a hard time about posting this property, and I hand-delivered the notice. And 10 working days were provided to correct the violation. On April 4th, the reinspection was performed and observed that an SUV was parked on the street and did not have a current tag. While taking the pictures, the owner came outside and moved the vehicle to the side yard. I notified my supervisor, and she called the owner later, and the owner of the property stated that he has a business buying and selling vehicles, and he will need until the end of the month to come into compliance. The supervisor agreed to work with him for the violation to be corrected, and 3 photos were taken. On May 1st, I verified that the property was still in violation, and 2 photos were taken. On May 2nd, a statement of violation and notice of hearing was sent by certified mail to the owner, posted the property in City Hall, and 1 photo was taken. On May 2nd, I also received an email from the owner of the property across the street at 2970 Micah Court, located right across the street. She was showing proof of correction of her violation or her vehicle violation, and this picture was taken on April 29, and we can see the owner of 2971 Micah Court has an SUV parked again on the street without a current registration tag. May 11, a reinspection was performed, and I can verify compliance of either vehicle and the property is still a violation. Today also I went by the property and still can verify compliance of the vehicles having current registration tags. Photo was taken. Now he's moved the vehicle, the white vehicle, closer to the garage door and still can verify compliance. It is the city's recommendation that the respondent be found in violation of allowing abandoned vehicles at this location by the time specified. The city will recommend that the respondent be given until June 1st, 2023 to correct the violation, or a fine in the amount of $100 a day be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $265.70 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation.
Respondent? Just tell me your name just before you start.
Hi, Your Honor. My name is Nathaniel Mejia.
Anything, and you were sworn in earlier, correct?
Yes, sir.
Okay, go ahead.
Okay, to my defense, 2 of those vehicles that she showed there has already been registered to my name. I have proof of insurance. I have it on my phone. I'm not sure if she just looks at the property and sees that they're the same type of...
Have the tags been put on the vehicles?
That's correct, to my name.
But the tags are on the vehicles?
Oh, yeah, right now, as we speak.
When were those tags put on the vehicles?
For one of them, I believe it was probably over a month ago. So she's been twice to the property since I put registration on that one, and yet she's still presenting that vehicle. The other vehicle is completely gone. It's gone.
When was it removed?
That one was removed exactly 2 months ago, and the pictures show that that vehicle is no longer there. So I did speak to her supervisor, and I explained that I would be compliant, and I have, because, again, I registered one, and I got rid of one. I just got one vehicle left there with no registration, and I'm compliant. Slowly but surely, but I'm making it happen.
Will you be able to have that one registered by June 1?
Yes, that'll be no problem. Either
Sure?
either register or removed, I guarantee.
Okay.
Yes, sir.
Then this is an easy case, because that's all the city's asking for today.
Okay.
That and to pay the cost of prosecution.
Okay.
And you do still have one vehicle there.
That's
So
correct.
you are in violation. I will find in favor of the city, find the respondent is in violation. Order the respondent to cure by June 1, 2023. Will order the respondent to pay the administrative costs incurred. That amount is $265.70. As you've heard in the other cases, typically I will give 7 days for that to be paid. If it's a hardship, I will always entertain a request for more time if you'd like more time to pay
Sure,
that.
if I can get more time, I will greatly
How much
appreciate it.
time do you think you need?
Probably a month, no problem.
Okay, then I'll make that 30 days to pay the administrative costs.
Sure.
If the vehicle is not tagged or removed by June 1, a fine of $100 per day will run from that point until compliance is met. Most important thing probably I can tell you today, because you already sound like you're 9/10 of the way there to compliance, don't let it happen again, because you also got to hear a repeat violation case, and those can get expensive quick.
Sure, and then one of the vehicles she mentioned there, it is registered. I don't know what they were looking at. The vehicle where they're showing the picture from the neighbor's house to Mike, that vehicle been registered for months. Never
So-
been unregistered at that property. to
In
be
the
honest with
order that she'll receive, the written order that she'll receive, it's gonna have language in there that says it's your responsibility to contact the code enforcement officer and schedule an inspection.
Okay.
As soon as you get that last vehicle either off the property or tagged, get the community compliance officer out there, walk the property with her, and if there's any questions or issues, that'll give you both an opportunity to address them before we get to that June 1 compliance date.
you. Sure,
Okay?
thank you.
I just made something. He can just turn the cars around so I can run the tags. There's no need for me to walk the property. I can do it from my vehicle. Thank you, sir.
Okay. I don't know, did you hear that, sir? That if you'll notify code enforcement once once it's in compliance, if you'll make sure that all those tags are visible from the right of way, you don't even have to be there. She'll drive by and confirm, and then I assume you'd reach out to him if you saw an issue. Yes? Okay.
Case number 2023-245, Sharon A. Weissenberger, owner, Edwin C. Koch, owner, location of violation 1549 Cypress Woods Circle, St. Cloud, Florida.
Good afternoon, April Bennett, Community Compliance Officer for the City of St. Cloud. I am presenting this case for the property located at 1549 Cypress Woods Circle. At this time, I would like to enter into evidence the following items: copy of the notice of violation sent by regular mail, copy of the notice of violation second request sent by regular mail, copy of the notice of violation sent by certified mail, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $254.70, and he is here today. Okay. On February 13th, during routine patrol, I observed an accumulation of lawn equipment and lawnmower parts in the front yard. Property kept in an unsanitary condition at this location. I sent out a notice of violation by regular mail to the owner of record, and 4 photos were taken. On March 6th, a re-inspection was performed and the violation was not corrected. 4 additional photos were taken. On March 7th, I sent out a second request notice of violation by regular mail. On March 22nd, a re-inspection was performed and the violation was not corrected. 5 photos were taken. On March 31st, a re-inspection was performed and the violations were not corrected. I also at that time added an abandoned vehicle to the case because it appeared that the yellow Corvette in the driveway was inoperable since it hadn't been moved since February. 8 photos were taken. On April 3rd, I sent out a notice of violation by certified mail. On April 6th, the certified mailing was signed for. On April 14th, a re-inspection was performed and the violation was not corrected. 4 photos were taken. On May 1st, a re-inspection was performed and the violation was not corrected. 2 photos were taken. On May 4th, I sent out a statement of violation and notice of hearing by certified mail, posted the property in City Hall, did an affidavit of posting, and one photo was taken. On May 6th, that certified mailing was signed for. On May 11th, the reinspection was performed and the violations were corrected. All the accumulation of lawnmower and lawn equipment and lawnmower parts was removed, and we were able to observe that the car was operable. He was able to drive it around the block for us to show that it does work, and we took 4 additional photos. It is the city's recommendation that the respondent be found in violation of having an accumulation of lawn equipment and lawnmower parts in the front yard, property kept in an unsanitary condition, an abandoned vehicle, and not corrected by the time specified. The city would also request that the costs incurred in bringing this case before the special magistrate in the amount of $254.70 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation.
Okay, can you go back to, let's scroll back through photos. I just want to ask a question for the benefit of the respondents so there's an understanding of what can and can't be done. Let's find a,
How far?
I'll tell you when, you keep going, I'll tell you when to stop. Let's stop here.
Okay.
So this photograph, can you explain for everybody what the issue is?
So the abandoned vehicle, or what appeared to be an abandoned vehicle, was the yellow Corvette. In front of the garage, there's always the lawnmower parts. This one was taken to show that he had an engine hoist. In the previous photos, that had been removed, but there was still lawn equipment and lawnmower parts in the driveway in front of the vehicles.
So the lawnmower parts, I think everybody understands. If it were just, because I think the red item behind the car, that's an actual working lawnmower, right?
It's a lawnmower. I'm not sure if it's
Can
working,
you keep
but
the lawnmower
yes.
there?
Not the accumulation that he had. One lawnmower is fine, and there's
Right.
one
So
now
it
on the
was-
other side of the property, yeah.
The things that I see, and I don't want to speak for code enforcement because you're the ones who go out there and write the notices. I just want the respondent to understand, what the issue was, because there are some gray lines when it comes to accumulation of junk and debris, as we all know who do this. That one item might not get you there, 6, 7, 8 probably is going to, but particularly when you have non-functioning things or parts of things, that's, from my perspective, often I think where code enforcement really starts to see an issue. But I don't want to speak for code enforcement.
Yes, and we had a conversation with him. Supervisor Howes went with me on the last reinspection that we did and had a conversation with him, and he's in complete understanding on what he's allowed to have there now and what he's not.
Okay, great. Thank you. And respondent?
Were you here when we swore in? I think you were downstairs, right?
I was downstairs.
Okay.
Do you have anything you want me to hear? I won't even make you come. Okay, then come on up and I'll swear you in. If you would raise your right hand, do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. And your name first, please.
Edwin C. Cock.
Okay.
Yes, as you saw from the pictures, according to the standards or whatever, yeah, it was messy. Okay, that vehicle is always ran. The reason why it might look like that, and I explained to him, because it says you got a tarp over it. I says, well, that's because the T-tops leak, and to keep the rain out of it so it doesn't destroy the interior. Okay, I took it around the block for him, showed him that it ran, it's licensed, registered, insured. But there is something that she was talking about, and now noticing here in what she gave me, with some of the letters she said she sent, I didn't receive. I received one certified letter, and she says she sent 2 certified letters. The signature on the second certified letter here is not my wife's signature.
What's the date on that letter? Or the date on the signature card, either one.
5/4. As you can see, if you go back to, I don't know if you have this, because on the first one,
Yeah, I see what you're saying. I see a 4-6 that has one signature, and I see a 5-6 that has initial S and,
Well, no, there's a, where was it? There was another certified letter, the first one that we got.
That should be right in front of the additional one. They're in
Is
order.
it?
Yeah, they're in order. Right there.
Okay, look, that's my wife's signature. That's not my wife's signature. They didn't even spell the name right.
Yeah, unfortunately, those are returned to us from the post office, so I don't know,
yeah,
did you
well,
maybe
I'm-
have somebody at the house that would have signed
No.
her name, or?
No.
Yeah, I'm not sure, because it's.
which,
No,
which
my-
date is the signature, is the signature's being discussed? Is the 4-6 or the 5-6?
You know-
The 5-4 is the one that is, the 5-6 that was signed is being questioned. See, for us, we get this that says that it was delivered to that address, so
Yeah,
that's what we
no,
have to.
I know,
Yeah.
I'm not I'm just saying, I never got,
Never got the letter.
right, and I don't know who signed for it.
Well, the 5-6 delivery, well, that would have been your notice of hearing, correct? So did you receive the notice of hearing?
I received, she put one,
Oh,
In the front
You
yard.
received the notice of hearing, and then you're here today, but yeah,
yeah,
that
I'm
5-6
here.
green card would have
Well,
been.
I had them come out and inspect, you know, and I've always been, yeah, okay, I'm a little lax. I'm not gonna deny it. But when they come, you know, and they can come up, knock on my door and tell me, hey, Ed, you're getting a little sloppy. Clean it up, and I will work with them. I always have.
Yes, but
You know,
also understand that
but-
these code enforcement officers are monitoring a lot of properties in this city.
I know, and I understand, but I mean, if they're gonna come and put a sign up, they could come knock on the door and say, hey, Ed, you're messing up again. But I'm just the second one, and I don't know how I should proceed with it.
Thank you for raising that. I don't know exactly how to tell you, but it is interesting. So there's no prejudice to the case because that was the notice of hearing, certified mailing, and so you're here. So one form or fashion, you were aware of the hearing, which is the point of that. My only guess is, only person I can think of that would have been Postman, but then they had signed COVID-19, and I don't think I've seen one sign COVID-19 in a while, but yeah, that is very, very odd. But so I don't find any prejudice to the case, but thank you for pointing it out, and certainly, yeah, keep an eye on your mail.
Oh, and no offense to the postal service, but their mail delivery is not up to par.
Yeah. Anything else you'd like me to hear?
No,
Based on the evidence testimony received, don't walk off yet because we'll have a question for you. We'll find in favor of the city, find that there was a violation of code. It has been cured. The significance of that, like you heard me say in a prior case, don't let it happen again because then you fall into repeat status and they can ask for more fines and it can get more expensive very quickly. So try to stay on top of it. Don't count on them. They don't have a duty to tell you to fix it before they come to me. So try to stay on top of it.
okay, but
They are good about that. They do try to work with respondents, but
I know, and
not their
I've worked
responsibility,
with
it is yours.
Melissa, and, you know, it's never been a problem as far as I'm concerned. I don't know, you know. Yeah.
I will enter an order awarding the cost of prosecution to the city in the amount of $254.70. As you heard me say earlier, I'm flexible on the time for payment. Typically, I say 7 days, but if you need more time, I'm happy
And
to.
maybe 30.
30.
But just one more question, and you had brought it up about, you know,
How much is too much?
if my lawnmower breaks down, because they told me, well, and I'm not sure how it was kind of stated that I couldn't have anything out there. So if I have a lawnmower that breaks, it's breaking, and I asked you, can I change the oil on it in the driveway? You know, just being a little sarcastic.
We have a gray line here because.
I was just being a little sarcastic,
I know.
you know.
Mr. Ed has been working on lawnmowers for quite a while. So, we're to a point now where I've told him he needs to either move to a different location or, you know.
Retire completely.
Retire. I said, if you have one lawnmower in front of your garage, then to me that means you're working on your own personal lawnmower. So that's where we stand. There can't be parts and, you know, I mean, if you're working on your own, you're only gonna have a few parts here and a few parts there, but,
We have an understanding.
Yeah.
And as a hearing officer, I would back up what you're hearing from community compliance, which one lawnmower is one lawnmower, multiple lawnmowers. If it's something that's being used in the maintenance of the house, that's usually, that will stay, outside of code enforcement. If there's multiple lawnmowers out there, you're not using multiple lawnmowers to mow your own property, that starts to catch the eye. Parts, broken things. But I would say more than anything else, probably, it's not just amount or functioning, not functioning, it's everything plus how long. One lawnmower out there not being run, not being taken care of for 6 months, in this weather, it's going to deteriorate quickly. It's going to go from a lawnmower to trash within a matter of months.
Yeah, I
So
understand.
it's kind of a moving target sometimes.
Yeah, don't get me wrong, I understand I wasn't in compliance.
And I
let
appreciate,
it
and I
slip
code
a
enforcement
little.
appreciate your honesty, and that's what I like to see is in these hearings, somebody, yep, screwed up, won't let it happen again.
I'm not going to deny it. I've never denied it. I take responsibility for my actions.
Okay, and I am going to allow 30 days for the payment of those costs. Okay?
Okay.
Thank you.
Case number 2023-286, Aziz Revocable Trust Owner, Bree Hess Patty, Aziz Trust Owner, location violation 206 Kentucky Avenue, St. Cloud, Florida.
Good afternoon, April Bennett, Community Compliance Officer for the City of St. Cloud. I'm presenting this case for the property located at 206 Kentucky Avenue. At this time, I'd like to enter into evidence the following items: copy of the courtesy notice sent by regular mail, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail posted on the property and City Hall, copy of the notice of violation sent by regular mail, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $259.70, and they are not here. On February 15th, during routine patrol, I observed high grass and weeds and a fence in disrepair at this location. I sent out a courtesy notice by regular mail to the owner of record. On March 7th, a reinspection was performed and the violation was not corrected. I sent out a notice of violation by regular mail and took one photo. On March 20th, a reinspection was performed and the violation was not corrected. One photo was taken. On March 21st, I sent out a notice of violation by certified mail. On April 5th, a reinspection was performed and the violation was not corrected. 2 photos were taken.
Has there been any improvement in the overgrown grass or vegetation?
The main part of the yard was mowed, but they're not doing any of the trimming. So there's a lot of high grass and weeds still around the fence line.
So that's what I'm seeing
Yes.
there, kind of in the periphery of the photographs and
Yes.
along the fence line is where the overgrown conditions
Correct.
exist.
It was kind of hard for me to zoom in from where I was at. On April 10th, a reinspection was performed and the violation was not corrected. I sent out a notice of violation by regular mail, posted the property and City Hall, did an affidavit of posting, and took 7 photos. On April 27th, a reinspection was performed and the violation was not corrected. 4 photos were taken. On May 4th, I sent out a statement of violation and notice of hearing by certified mail, posted the property in City Hall, did an affidavit of posting, and took 5 photos. On May 6th, the certified mail was delivered. On May 15th, a re-inspection was performed and the violations were not corrected and 4 photos were taken. It is the city's recommendation the respondent be found in violation of having high grass and weeds over the height of 8 inches and a fence in disrepair at this location and not corrected by the time specified. The city would recommend that the respondent be given until June 1st of '23 to correct the violations, or a fine in the amount of $100 a day be assessed until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $259.70 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Respondent present?
No,
No respondent? Have you heard anything from respondent?
no.
Anybody sign in for the green cards?
I do not, I'm sorry, give me 1 second.
Nope.
No. The first green card was sent back,
Unclaimed.
returned just under unclaimed, and then the other one does say that it was delivered to an individual at the house, but they did not sign the green card.
The evidence is clear, fine in favor of the city. I was sitting here trying to think if there was anything that I could help you in some way get their attention other than the order that they'll receive from me. Because they're taking care, they're mowing, like you said, they're mowing the main part of the grass. They just aren't taking care of the fence line, and then that fence is abysmal. Find in favor of the city, find that respondent is in violation as presented by the city. Order the respondent to cure the violations by June 1, 2023. If not brought into compliance, a fine in the amount of $100 per day will run until compliance is met. Also order the respondent to pay the administrative costs in the amount of $259.70, which amount will be due within 7 days of the date of my order. Do you have any knowledge of, just because it's a trust, do you know if it's an elderly person who's living there?
She has tenants that live in the home. She lives at another location. From my understanding, I believe Alex has had issues on other properties with her, and I think according to the family members, because of her age, she's forgetting a lot of things. So there may be some issues there, but
Hopefully the order will prompt her to maybe make a call to her tenants and get them to fix it.
okay.
Okay. Thank you.
Thank you.
Case number 2023-616, Brady Bennett, owner, location of violation, 2010 Pine Street, St. Cloud, Florida.
Good afternoon, April Bennett, Community Compliance Officer for the City of St. Cloud. I'm presenting this case for the property located at 2010 Pine Street. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, copy of the notice of violation sent by certified mail, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $265.70, and they are not here. Oh, I'm sorry. Let me give you. All right, so I wanted to provide a little bit of history on this property before I get into this case. This is the third time that the property has been written for the same violations.
First time I've heard it though, right?
The first time you've heard it, yes. The last time it was written in July of '22 by Officer Miller, and then that was brought into compliance within 15 days. Then when it became my area, I wrote it again in September of '22, and it took 112 days for them to bring it into compliance. So that starts where we're at now. So on March 31st, I received a complaint from a neighboring property. In the rear yard, there was an accumulation of dead Christmas trees. The complainant was concerned because it is a mobile home park that if that was to create a fire because of the dry conditions, that it could create an issue for the whole neighborhood. While doing the research on this complaint, I observed high grass and weeds, an accumulation in the front and in the rear yard, and 8 photos were taken. This is taken from the street behind, so it's kind of hard to see, but the dead in between the properties is from that view of the dead Christmas trees.
The brown in the center of the frame.
Yes, yes, that's from the street over, so I could get a shot of the rear yard.
What am I looking at in this photo?
So this is some of the accumulation in the front. There's stuff in the driveway. The 2 trucks that are usually parked on the side yard over there are always full of miscellaneous items. They don't move. So they appear to be abandoned. So that's what's in that photo.
What am I looking at? We'll go back. What am I, or this one too? It's same, different angle, same photo. What am I looking at in this photo?
Just the accumulation of items. There's the trailer out there. There's another boat in the driveway. It's kind of hard to see. There's in the background the accumulation of things in the driveway behind. That truck sat with the hood open for quite some time. There's some, I don't know what they are, like poles leaned up against the truck in the background. I think I've got a closer picture of that. Give me a second, let me. And that's the accumulation of the trees. And then that's the truck with the accumulation in the bed. There's tires are usually all over the side yard. So that's just another photo a little bit closer. On April 3rd, I sent out a notice of violation by regular mail to the owner of record. On April 14th, a reinspection was performed and the violations were not corrected. I sent out a notice of violation by certified mail. 6 photos were taken.
Where is the high grass and weeds on the property?
It's the shadow, but they're along the, again, they're not, it's more trimming. It's not being maintained along there.
Along fence lines.
And then,
and along, looks like along the side of the structure too.
Right. And then that picture shows a little bit more of it and then into the rear yard.
But so it is just kind of the fence line and the structure.
Correct.
It's string trimming, not mowing, really. That's the issue.
Correct. On April 17th, a notice of violation was posted at the property, City Hall, and an affidavit of posting was completed and 9 photos were taken.
Are you in communication with the respondent?
Not this time around. The tenant has reached out to me recently to let me know that some of the things were corrected, but I have that a little bit in just a second. On April 27th, the reinspection was performed and the violations were not corrected with the exception of the Christmas trees. Those were removed. During this inspection, I was approached by the tenant who asked for another day to have the accumulation cleaned up. I agreed to come back the following day. At that time, 1 photo was taken. That was that one. On April 28th, a reinspection was performed and the violations were not corrected. 3 photos were taken. On May 3rd, a reinspection was performed and the violations were not corrected. 7 photos were taken. On May 4th, I sent out a statement of violation and a notice of hearing by certified mail, posted the property in City Hall, did an affidavit of posting, and took one photo. On May 15th, a reinspection was performed and the property is not in compliance. 5 photos were taken. I did receive an email last night around 6 o'clock from the tenant of the property to advise me that they had completely cleaned the property. I went there today and got some updated photos. I also asked Supervisor House to go by for me and give me her impression of what the property was, just to make sure. At this point, it's still not in compliance. Now one of the vehicles that is sitting there has flat tires, so it's still not in compliance. It is the city's
Other
recommendation.
than the vehicle, what's on the property?
So the trucks are still sitting there with the accumulation.
Full beds.
And the beds. It does look like some progress was made underneath the carport area. There's still the tires, there's still the high grass and weeds. Unfortunately, because I went today, I didn't get the photos uploaded. It is the city's recommendation that the respondent be found in violation of having high grass and weeds over a height of 8 inches and accumulation of rubbish and miscellaneous items in the front and rear yard and not corrected by the time specified. The city would recommend the respondent be given until June 1st of '23 to correct the violations, or a fine in the amount of $100 a day be assessed until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $265.70 be paid within 7 days of the magistrate's written order. This concludes my presentation.
Thank you. Respondent?
Good afternoon, sir. My name is Bill Barrett. I'm here on behalf of Brady Bennett, the owner of the property. I'd like to ask a couple of questions first, if I could, please,
Sure.
of Ms. Howes.
For Ms. Howes or Ms. Bennett?
Ms. Bennett, excuse me, Ms. Bennett. Ms. Bennett, you cited the 2021 International Property Maintenance Code in this. Is the 2021 International Property Maintenance Code the official code of the city as adopted and incorporated into the city ordinances of the city of St. Cloud?
Okay, so I don't feel that I'm qualified to speak on this, maybe Jack will, but so from the reading of our ordinance, the wording of it states, I'm not sure exactly how it's worded, but 2009 and then any new additions is basically how it's worded. It's being called into question because we do use the current edition, which is the 2021 version of the International Property Maintenance Code, and that's what we quote in our violations. We don't have the 2009 written in there anymore, and there's a discrepancy on the wording, I guess, in our ordinance. But like I said, it's for us, the way it's interpreted is it says the 2009 or any further additions that are adopted by the city. So again, the 2009 is quoted in there, but the wording of it does mean other additions. So what I am using is the 2021.
Anything to add, counsel?
No, just that the city's position is that it's adopted the International Property Maintenance Code sections as relevant through the St. Cloud.
Well, if I'm looking at section 1033 of St. Cloud City Code, subsection A, adoption of the 2021 edition of the International Property Maintenance Code as adopted by the International Code Council. So is there a question as to which version of the code is applicable? You asked the question, yes, sir.
Yes, sir, there is. I had a couple of other questions. I will get into that in just a second if I could finish the other couple of questions.
Go ahead.
Has your supervisor or the city attorney, Mr. Manzares, informed you that the 2021 IPMC is not the official city code?
Okay.
Okay.
Mr. Barrett, are you an attorney?
No, sir. I'm a government relations consultant. Sir, the reason why that's in question is because I've been in contact with Mr. Manzares over the last 2 months on several other cases, one of which was supposed to appear on this agenda today and was removed about 2 weeks ago for this very reason. I have the email that I sent to Mr. Manzares, which I'll give to you in just 1 second, if I could read it, please. Sent to Mr. Manzares on April 24th, 2023, copied to Veronica Miller. Dan, the attached notice of hearing, talking about the other one that was pulled, the attached notice of hearing still lists the 2021 IPMC as the violations. I thought after our last conversation that the 2021 IPMC was not city code. Please review and advise. That was on April 24th. On April 28th, Ms. Bennett reissued a new notice of violation that noticed the 2009 International Property Maintenance Code. And then on May 2nd, I received an email from Mr. Manzares, which Mr. Morrison was copied on from his boss, Mr. Manzares. And it says, Bill, a new notice of violation has been sent. And if the property is not in compliance, a new statement of violation for the July special magistrate will be sent. I also have from March, where I was given both by Mr. Manzares and the city clerk, that the 2009, I'll give you the date.
Let me get
March.
this down to, you're going down a road that's probably not going to be persuasive to me.
Okay.
Let me boil it down to brass tacks.
All right.
Does the 2009 International Property Maintenance Code allow high grass over 8 inches?
Sir, I don't know what that is. The
It
codes.
does not.
The
I'm familiar
codes.
with it.
Yes, sir. The codes are different within those. If
It
we
is.
look at
I'm
them,
aware
they're
of that,
not the
but
same.
neither allows the condition that exists on this property.
I'm not going to argue that fact against you, sir. I'm just saying if this is the correct code or not, because we have to be charged with what we are actually responsible for.
You're charged with overgrown grass in excess of 8 inches.
Okay.
You're charged with rubbish and miscellaneous debris.
Under
Notice
the
of violation stated both of those items.
Under the 2021 code?
It stated both of those specific items. Did your client do anything to fix it?
He's contacted his tenants and has had them working to bring it in
And
compliance.
they've begun. Have they fixed it?
I'm not aware at this time whether it's been fixed or
Are you
not.
arguing to me that there's not a violation on this property?
No, sir, I'm not.
Are you arguing that you were not aware or that your client was not aware there was a violation on
No,
this property?
sir, I'm not arguing that fact. He said that he did receive the first notice, but he didn't receive any notice for this meeting. And that he thought that after the first notice of
You're here
violation.
for the meeting,
it was
so somebody
because-
received notice of hearing.
Yes, sir, because he didn't receive notice of hearing
But you're here on his behalf. How
Yes,
are you
sir.
here on his behalf if he didn't know there was a hearing?
because I called him and told him there was a hearing.
Okay, so somebody's
And I
here,
informed him.
due process has
Right.
been met.
I was trying to answer your question as to the mail issue. I thought that was the question
No,
you were
did
answering.
not ask
I
about-
apologize for that.
It's okay. And I don't mean to cut you off, but I don't want you to spend time arguing something that's not going to persuade me.
Okay.
Because I am familiar with these codes.
Okay.
And there was specificity given in that notice of what the condition was.
Mm-hmm.
And I do find that IPMC 2021 and 2009, based on junk and debris and overgrown grass, they're actually identical. That language has not changed in those two versions. But I find that there was plenty of notice as to what condition needed to be cured. I'm not going to rule in respondent's favor on a technicality of which date was used.
Very good, sir.
Is there anything else you want me to hear? And I don't mean to cut you off, but I've done this for a long time through both of those code iterations.
The point that I was making is that according to the city attorney and the city clerk, the 2021 IPMC is not city code. And if we're going to be charged with a violation, you have to be charged with the proper violation. And that's the point of this. He is bringing it into a compliance. He is ensuring that his tenants are bringing it into compliance.
Okay. Any hardship to your client? First off, June 1 is the compliance date requested. Does your client, is that achievable, is that an achievable date?
It should be an achievable date. He is working with his tenants to get the rest of it cleaned up. Now that we have an updated listing of what's still not done, and I will make sure that he gets that this afternoon and that he's in contact with his tenants.
And is there any hardship in paying the administrative costs of prosecution, $265.70 due within 7 days? Is there any hardship in paying that within 7 days?
I would ask that you, if you could give him an extra week into that,
I'll give them 30 days.
that would be
Review the
great.
cases.
That would be
Yeah, no problem.
outstanding. Thank you.
And again, I apologize if I seem like I was coming across as aggressive with you. I did not mean to, but it's that is a frustrating argument to me. Not your fault for making it. But for anyone who comes in and says, well, 2009 versus 2021, yes, I know I can't have my grass this tall. Yes, I know I can't have this condition, but I don't like the code you cited me with. That gets to me. Because everybody knew. We can look at the pictures and we can see this is not an okay situation. And it's tricky, I know, because it's a tenant, not your client. But everybody knew that condition needed to be fixed. That is my finding. I find in favor of the city, find the respondent is in violation. I'm gonna go ahead and give until June 8th. I'm gonna give him that, not the week he asked for, the week for the money, but I'm gonna give him until June 8th, just to make sure if there is any delay, you have that time, or your client has that time to work with his tenant, get it taken care of. If not brought in compliance by that date, to find the amount of $100 a day to be assessed until compliance is met, or the administrative cost to be paid, $265.70 to be paid within 30 days of the date of my written order. Good, thank you.
New business, none. Next scheduled meeting, June 21st, 2023.
Anything else from the city? No, sir. I'm not adjourning this yet. I'm looking at something. Update your notices. We're all good. And we are adjourned.
On the evidence from Hickory Tree, do we stamp every page or just the first page with responding evidence one?
You can exhibit one.
Because I know like in what they.
Composite exhibit one if you have one, but otherwise just
No, we
exhibit
just
one.
have, respondent exhibit and then the line to put the number. Okay. This one, yeah, I'm on that one page.
That's fine.
Yeah, that was. I'll look through that. I'll look through that. And then, you know, like,